The Fourth Amendment, criminal procedure, constitutional protections, these are all important issues that Donald Trump is trying to violate through his mass deportation campaigns. And we're going to talk about that today. I'm Shant Karnikian. That's Brian Kabateck. This is Civil Action on the Legal AF Network. And today we have a special guest. We have Professor Stan Goldman, who's a law professor of mine and a professor of Brian's. Brian, why don't you introduce Stan?
Sure. And my honor and pleasure to introduce Stan. Stan Goldman is the longest serving tenured faculty at Loyola Law School. Professor Goldman has been himself a public defender. He's an incredibly well-renowned author. He is a specialist in criminal law and criminal procedure, having taught that for many, many years. Sorry to make you feel old there, Stan, but it is true. You've taught this for a long time. Stan has written articles on stopping people and searching people, but the police, what they can and can't do. And I'm proud to tell you that Stan also has written a book, Left to the Mercy of a Rude Stream. This book is available on Amazon. It involves the Holocaust and his mother's experience with the Holocaust. And I believe that there are certainly comparisons about Nazis stopping people on the street and asking them for their papers with what's exactly going on today. So Stan, I wanted you to come on and talk to our viewers about what the police, the Border Patrol, ICE, all of these government agencies can and can't do when it comes to merely stopping somebody on the street and asking them for their documentation that they're a citizen.
Well, you can't do it. I mean, you can do that in Europe. I mean, that's always been one of the things that separated us from Europe is you need to keep your papers with you when you're traveling through a European city, but you never had to here. In effect, people always sort of considered a right to travel, which really exists for Americans. We don't have to produce our ID now. If the Supreme Court, in its infinite wisdom a number of years ago, said that if the police already have a reasonable suspicion that you are engaged in criminal activity, it doesn't require probable cause, but it's more than just a hunch. It's a reasonable, articulable, meaning you can explain what the suspicion is. You got a reasonable suspicion that someone's involved in criminal activity, not enough to arrest them. You have the right to stop them and question them. And you then have the right to ask them to show you your ID. And if you can't produce it, the Supreme Court years ago said under these circumstances, it might, depending on the case, be sufficient to put the person in custody on the grounds that they haven't dispelled the reasonable suspicion, and perhaps that's raised the bounty now on them to probable cause. So it's possible that can happen, but you can't just stop somebody on the street.
Two questions on that point. Zooming out a little bit before we get to that, who does this apply to? Is it true that this applies to anyone, regardless of
the Constitution applies to everyone in the country who's here in the country, lawfully, unlawfully. It applies to everyone in this country, theoretically. It applies to citizens, non-citizens. The due process rights of the Constitution apply to everyone.
And what's the reasoning behind having that requiment, the articulable suspicion requirement before stopping?
Well, it all stems from, we have a Bill of Rights in this country. And the fascinating thing about the Bill of Rights is we just don't know why some of them were included. I mean, there's a famous line from Justice Harlan who said much of the Bill of Rights comes to us upon faded parchment, meaning we have no idea why it's there. We know exactly why the Fourth Amendment privilege against reasonable searches and seizures, both searches and seizures, it was created. It was created because the British, when they were governing the colonies, would stop people, would come into colonial homes, and we wanted an absolute protection against an all-powerful government being able to duplicate that oppression, which is the way the founding fathers viewed what the British troops had been doing in stopping people and breaking into homes and just not having a warrant or probable cause. So that's the one provision we absolutely know where its origin is. It's very clear historically.
Okay, Professor Goldman, let me just go through kind of a hypothetical with you here so that people understand this. Someone in Los Angeles, which is where your law school is, where we're based, which seems to be the flashpoint for a lot of immigration, undocumented worker activity. somebody is simply walking down the street, they're Latino, they speak with an accent, and ICE drives up in one of their big military vehicles, and these guys pop out and they start, searching the guy, asking him for identification. Go through that. Explain that. That's simply not legal, right?
Yeah. God forbid. No, that's not legal. That is completely not legal. You would need a reasonable suspicion to believe they are in fact a criminal, or because it's not crime, illegally in the United States. In other words, if they entered without permission. That you'd have to have a reasonable suspicion. The color of their skin, the fact they're speaking a foreign language is not. We are a country of immigrants, right? Everybody here, their parents at some point, or grandparents or great-grandparents came here and spoke a different language. Even Native Americans spoke a different language than English, or American English when they arrived. Even if they came from England, it was slightly different. So you can't just based on someone's accent or the language or the color of their skin. That absolutely verboten. You mentioned the Nazis, and I don't like comparing people in America to Nazis. Obviously, the Nazis were, kind of sui generis. But that's one of the distinguishing features between a democracy that has civil liberties and civil rights for everyone, as opposed to an authoritarian government that can just do whatever it wants to its populace, like, stopping them, frisking them. Right. Yeah, this was, in New York some years ago, they had this policy of being able to stop and frisk everybody, hoping it would reduce crime. And it maybe it did, maybe it didn't, but it didn't produce much results. Very few people actually were discovered to have like weapons or something on them, but it was also unconstitutional. You can't just stop people because you think they look suspicious. You have to be able to articulate a reason. And if your articulated reason is they look like they were foreigners, that's not a reason.
So I don't want to dominate all the questions here, Shant, but let me just ask one more. Is that, there's plenty of news stories about Home Depot and day laborers hanging around outside Home Depot, which is traditionally a place that people get picked up to work on projects 1 day, 2 days, something like that. How about that? Is that enough for ICE to come in there in their vehicles and say, okay, you guys are day laborers. We want to see your ID to see if you're U.S. citizens.
No, that is not. I will say this though. Once again, I happen not to have agreed with this opinion by the Supreme Court, but who the hell cares? Now, some years ago, the Supreme Court was confronted with a case in which a factory owner had given permission for immigration to come into his factory. Or at least he consented to it after a warrant was obtained to get into the factory. And they stopped at the worker. They went to workers while the workers were working on an assembly line and asked them questions. And the U.S. Supreme Court, I believe an opinion by then Chief Justice Rehnquist, said, well, that isn't technically a stop. That isn't technically a seizure requiring reasonable suspicion. It's just a conversation, and nothing in the Constitution prevents a law enforcement officer from starting a conversation with someone. So we have this strange, parsing of stopping someone and making them talk to you as opposed to going up to them and chatting with them. It doesn't mean they have to speak to you. It doesn't mean they have to respond. It doesn't mean you can treat their failure to respond as part of the reasonable suspicion to then detain them. But there is a difference between starting a conversation with someone and actually seizing them, meaning you can't leave. I want to talk to you until I'm done talking to you and getting the answers I want to get.
And that reminds me a little bit about like the law on DUI checkpoints, for example. Like checkpoints are legal, except folks aren't obligated to speak with the officer or answer questions, right? Technically, they're not.
Right. It's possible that they'll discover something in the stop that will give them additional information, which might rise to the level of reasonable suspicion. But look, as I said, the whole point of the Constitution was the government can't just do anything it wants. And they were very sensitive to this when they wrote the Bill of Rights. that privilege against self-incrimination and counsel and the right against unreasonable searches and seizures. And nothing could epitomize an example of a seizure more than seizing a person. People sometimes confuse this and think, well, it's seizing a piece of property. No, when you stop someone, when you arrest someone, you have seized them. And therefore the Fourth Amendment is dead on applicable to when they go up to people on the streets and not just grab them and throw them in the back of a truck, God forbid, but actually just go up there and say, hey, let's talk. And you say, not today, I'm a little busy. Hey, you can't say that to me, and then arrest them. You can't do that. That's, that's not what we do in this country. That's not what
Well, Stan, how about though pulling up in front of a bus stop, because this happened in Pasadena, in the town I live in, and it said, and they swarmed a bus stop where 4 gentlemen were standing, Latino, and they immediately came and said, are you citizens? Are you U.S. citizens? I want to see your papers, your documents. And they eventually arrested them and took them into custody.
Nothing, according to the Supreme Court and that majority opinion I mentioned, stops the police from going up and saying, hey, how you doing? Are you a citizen? I mean, they can say that. But if you look at them and say, have a good day, and turn around and walk away, there's nothing they should be allowed to do to you.
So they cross over when they
see your papers. They can start up a conversation with you. They can ask. I mean, I suppose anybody can go up to somebody else and say, hey, even the police, hey, you got a nice car there. You mind if I search the trunk? And if you give them consent under no coercion, then you've given consent. So sure. Can I see your papers? Are you a citizen? Oh, you are. Would you mind showing me your papers? And if that is not viewed as a coercive action, which I think, in my opinion, it would be, but if that's not viewed as coercive, theoretically, that's just conversation. Once again, the person could say, no, your papers, I'm not going to show you any damn papers. No, have a nice day.
Or they could say absolutely nothing.
There's nothing they can do to you.
Or they could just say absolutely nothing. They could just turn around and just completely walk away.
They don't have to answer that question. But the question is, are they being coerced? Are they really, would a reasonable person under these circumstances believe they are free to go unless they show their papers? If a reasonable person would think they were not free to go unless they show their papers, then that's probably a coercion.
Well, I think when a bunch of vehicles show up and guys jump out in military garb carrying M16s and guns and wearing masks, I think that sounds pretty much to me like coercion.
Of reasonably coercive behavior. You're absolutely right.
That's
once again, if they just got out and walked around and say, hey, how you doing today, buddy? How are the kids? You from around here? There could I have no idea what any high court's going to say when an explanation is given. But interestingly, in the litigation that's sort of taken place so far, or the responses by the federal government, they don't seem to be trying to give an explanation for their behavior. They seem almost entirely to be denying that they're doing it. Maybe that's because they know the answer if they admit they're doing it.
And a good example of that is the Vasquez-Perdomo decision by the Central District of California federal judge. Went up to the Ninth Circuit. The Ninth Circuit refused to overturn it so far. And now there's a petition pending before the Supreme Court. But in at least in Los Angeles, the judge said, you simply can't do that. You simply can't go up to people because of their race. You have to have articulable suspicion. You simply can't ask people for their ID. You simply can't engage in coercive behavior with this goal in mind. And to your point, Stan, is that the court, they gave the chance for the United States of America to explain itself, and they fundamentally didn't. And I think it goes beyond what you're saying. I think this is sort of self-righteous. We're going to do what we want to do. We're part of the Trump administration. We can do anything we want to do. And this is what we're going to do. So if you don't like it, too bad.
Yeah, I think they seem to believe that I can't believe they don't watch the videos and see this is exactly what's happening, but they seem to be denying factually here before they're going to make a legal argument that they have the right to do what they claim they're not doing. So first they're going to put the plaintiffs or whoever is involved in this suing them or in an action against them to their proof that they're actually doing it. And then and only then, if they're forced to, they're going to try to give an explanation.
Yeah,
and
but
I think that's because they have no explanation.
In this case, they don't even seem to deny it. There's the allegations that are made, and they come out and say, well, this is our mission.
Yeah.
This is our mission.
And the U.S. Supreme Court, once again, I'm not trying to be pessimistic here, but the U.S. Supreme Court seems to be prepared to give the government, the federal government, time to respond in each individual case, during which one wonders if this order that you're speaking of is being honored, because there's some argument that the government's just sort of ignoring it and doing this stuff anyway in Los Angeles. Maybe not quite the same numbers it did a few weeks ago, but still doing it. So, I mean, they don't seem to be abiding by the federal judge's order, hoping this thing just eventually gets to a court in which they have a friendlier audience to what they're doing.
Yeah. Stan, you've written about this. I want to talk about, I totally understand. And I think there's a consensus here, at least among some folks, that this is illegal. You can't do this. But what are the implications, maybe evidentiary implications? You were my evidence professor, for example. What are the implications when this happens, when the Fourth Amendment is violated? What happened? What recourse does a victim of that or the subject of that violation have?
Well, there are only really two recourses other than the injunctive relief, which is being sought at the moment in courts. And that is, one, if they found evidence on you after seizing you and searching you that was in some way incriminating, you'd have an argument at court to keep it out. It's known as the exclusionary rule. You can exclude from evidence something they find on you, but we're not talking about that here. What we're talking about is things in which they're just trying to stop people and frisk them. And you can, without criminal cases following it, maybe deportation cases, but otherwise no criminal case. So what we're talking about potentially is a lawsuit there's a section that's got a date, a name that people think is a date, but it's not. It's 1983. There's this provision of the Federal Code 1983 that says you can sue if your constitutional rights have been violated. You can sue the government. And in some cases, you can even sue the law enforcement officials who violated your rights individually. So there are lawsuits that are possible. I mean, some circuits, Brian mentioned the Ninth Circuit, some circuits have treated this more broadly than others. There was a Fourth Circuit, which is the area of the country like Maryland and North Carolina and that area, a few years ago that said, you can sue, but we're going to hold the plaintiffs to a fairly high standard here of proof that the government officials kind of knew they were violating your rights when they did it, or should have known. So it's not like a typical lawsuit, but it still provides for damages against the government. And I would say more likely here is getting injunctive relief and then seeking some sort of contempt of court in violating the court's order if the government still continues to proceed along with something the court has said you can't do. And that's what an injunction means. You can't keep doing this. And yet if they keep doing it, the question is, what can you do to them individually and as a group?
Well, Stan, this has been, terrific. I give my final thoughts at the end of these. It's just that, there's a lot here and there's a lot of legal issues. And I would love to have you back to talk about some of the other legal issues, including, unreasonable searches, which are warrantless searches or searches with warrants and where they could go. We talk about that. There's a lot of other issues here that I think folks are really fascinated on. So, Shant, as usual, you get the last word.
No, I just think there's a lot of issues here, but I also think that there's a lot at stake here, right? As Stan put it, this is like a fundamental constitutional right, and that's what makes our country a democracy. This is what makes it what it is. So these types of violations are a big deal. Aside from the fact that it harms real people, real families, hardworking people that are Americans. just because they don't have citizenship. And some of them who are being stopped do have citizenship. It harms, aside from it harming real people, I think it also harms the fabric of our democracy. So I think it's an important issue. And thank you, Stan, for sharing your wisdom on this with us. Thank you, Stan Goldman, everyone. I'm Shant Karnikian. That's Brian Kabateck. We're two lawyers at a firm called Kabateck LLP. This is Civil Action on the Legal AF Network. If you like this content, hit that subscribe button. We'd love to hear your feedback, and we'll try to have Stan on again.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.